Good afternoon. My name is Nathan Hochman. I'm the Los Angeles County District Attorney. Today starts the day of the preliminary hearing of David Anthony Burke, the singer David, spelled D4VD. This preliminary hearing will last approximately 3 to 5 days, at which point we will be seeking to hold David to answer for 3 felony counts of which he has been charged. First-degree murder with special circumstances, the count of lewd and lascivious acts with a 13-year-old, and the count of mutilation of human remains. David will be facing a maximum punishment of life without the possibility of parole, or he is also death penalty eligible. The decision on whether or not to seek the death penalty has not been made at this point. Now, the point of a preliminary hearing is somewhat different than you actually perceive in the media, whether it's TV or the movies. Because what often happens in TV or the movies is you go from an immediate arrest into a trial. But in our system and in California in particular, you have an intermediate step. That intermediate step is a preliminary hearing where effectively the prosecution's evidence is going to be tested before a judge, not a jury. The standard that we have to meet is not beyond a reasonable doubt at the preliminary hearing stage. It is probable cause. We are not obligated, nor will we be presenting all the evidence at a preliminary hearing that we will be presenting at a trial to prove David beyond a reasonable doubt guilty of the 3 felony charges of which he has been charged. So at the preliminary hearing, we will call a number of officers. We estimate there will be over 10 different witnesses, both officer testimony, coroner testimony, and there will be individual witnesses as well. And again, we can rely on hearsay and other things that won't be allowed to be relied on in an actual trial. The judge at the end of the presentation of the evidence, and again, this is evidence that can be cross-examined by a defense attorney, and that process has already been begun. At the end of the presentation of all this evidence, the question will be, will David be held to answer on the 3 felony charges? We believe we will more than accomplish the evidentiary burden of probable cause at this point to hold David to answer on these 3 felony charges. At that point, if the judge does hold him to answer, we will file an information that will detail the actual 3 criminal charges. Thereafter, there will be a trial date that will be set, and David, if he so chooses, will proceed to trial. And we will prove at that point, beyond a reasonable doubt, that David committed these 3 crimes. And when, and we do not predict if, when he is convicted, we will then be seeking the sentence that we are allowed to seek by order of the law, and we will let you know in a future date whether or not that sentence will also include the death penalty. So I wanted to take this opportunity as we're starting this preliminary hearing process to explain where the preliminary hearing fits in the process so people can understand as we are presenting evidence and it is being cross-examined what ultimately the standard is for the judge to determine, and that's probable cause, not beyond a reasonable doubt. It is a judge that is doing this determination, not a jury at this point, and that there will subsequently be a trial when the judge holds David to answer on these 3 felony charges. When this preliminary hearing is over, I will come back to address you, and at that point, I will take questions. Thank you very much.